Good morning, good afternoon, good evening, depending on the time of the day that you're watching this video from. My name is Angela Area Apicha.
My name is Aine Sheldon Bosco.
Hello, my name is Kalinda Jamada Musa.
Hello, my name is John Vianny Ayebare.
And I will be taking you through this video. So the purpose of this video is to basically address the challenge of lack of knowledge on bail application, and our focus shall be on the magistrate court system in Uganda.
In the case of Uganda and so many countries, we have a presumption of innocency. When a person is accused of a crime, usually the accusations at a certain point is only allegations that have to be proved. Why? Because the consequences of being found guilty of a crime are also there. For instance, you go to prison for so many years. In extreme cases, you can actually lose your life because you can be executed. So that's why the law also requires that there is enough evidence and there must be a process of proving that you committed the crime. But as you go through that process, you are presumed to be innocent. And that's where bail then comes in. The release on bail does not mean that the trial has been terminated, the trial goes on, but to minimize the interference with the enjoyment of a person's rights. So that's why you are allowed to go back home and continue going back to court. And of course, once the offense is proved against you, then of course the bail is cancelled and you have to go back to prison. The release on bail does not mean that you've been acquitted. It only means go home, but the trial continues. Because in addition to balancing the rights of this individual who is going through trial, you're also balancing the rights of others. So for instance, if I'm a breadwinner and I'm accused of an offense and put in prison for 2 weeks, 3 weeks, 6 months, a year, what happens to the people who depend on me?
Bail is specifically permission granted by court to an accused person to have their cases heard as they come from home or their places of residence, not coming from prison. Well, there are various types of bail, and one of them is cash bail. For cash bail, it's where a court grants you bail and you have to pay the specified sum of money that the judge directs immediately before you're released. And then for the non-cash bail, court grants you bail, but you don't immediately pay the money.
You can apply informally for bail in a magistrate's court orally by coming to court as the accused or the prisoner and raising your hand. Then the judge will ask you the reason why you've raised your hand, and you'd have to state that you'd like to apply for bail. Upon that statement, you'd be required to present the requirements for a bail application, and that is the sureties and the requirements of those sureties, or cash if that is a requirement that the judge has set. After that, the state prosecutor has the mandate to object to the bail application. And upon those objections, it is at the judge's discretion to decide whether or not you should be granted bail.
Magistrate will consider whether the person applying for bail has a permanent place of residence. Because the idea is, if you skip bail, are they able to find you at a certain time? Then secondly, the gravity of the offense is another consideration. What type of offense are you charged with? Then the magistrate will also consider whether you are a person of good character. What's your character out there? If they release you on bail, are you going to be a person of good behavior? Then lastly, you also consider whether you have substantial sureties. Now, a surety is a person who will guarantee that you will be brought to court on a date on which the court requires you to be in court. For someone to get substantial surety, he must present a national ID and a letter of introduction from the LC, and then you also have to be a person of 18 years and above.
Tell our viewers what your story has been.
Yes, I was taken by police from Kampala to Mbazira on the cases of buying a stolen item, a phone. But I was taken by police for the first time. When I reached Mbazira police station, I was detained for 2 weeks. For 2 weeks without court appearance. I was brought into court. When I was brought to court, I had my sureties, but they were denied bail because they were not people from within. And another case, that is the way I said, the sureties I had brought, some of them didn't know the exact location they were staying in from Mbazira there. So I was not able to be granted bail. But after, on the next court sitting, I was granted bail because I had my people who were from within and had all the confidentials to make it a success. That's why I'm out here on a court bail up the date I will appear back into court.
Okay. So Counsel George is highly experienced on dealing with bail, especially within the court martial. But does this extend even to those that are within that jurisdiction of a court martial system?
Constitution presumption of innocence applies to each and every person who is charged with a criminal offense. Yes, even in the court martial we do apply, and sometimes we do get clients released on bail. The challenge sometimes is regarding the technicalities that are involved in it. Many times we've had problems of the military court regarding the manner of it, especially when it's trying civilians, that sometimes they make injudicious judgments, because ordinarily when a person is making a ruling on bail, especially when you're denying bail, you're supposed to give reasons why you've denied. From my experience, most of the times when court martial denies bail, it doesn't give judicious reasons, such that a person has to apply not knowing what failed the first application. But yes, we do apply for bail in the court martial, and many times we have got clients released on bail. The same principles apply. Many times we make a formal application which we serve on to the state, and then it's heard and you present sureties, and the court makes a ruling and sets terms, just like ordinary other courts of judicature also set terms on bail. Ordinarily, when a person is denying bail, they should give reasons and examine. Maybe you've brought sureties and they're not substantial. They should give reasons why they haven't found them substantial, such that when a person is making a fresh application, they know what to address, which remedy to address. We've found problems with the court martial. Sometimes when it denies, it makes blanket statements, and leaving the person who is making a fresh application grappling and not knowing what area to address. But yes, if bail is denied, you can always apply afresh, and we have some people have been released on fresh applications.
When you look at it in its entirety, you realize that it is an important aspect of our criminal justice system.
With the presumption of innocence, you cannot remove bail unless you remove the presumption of innocence, which wouldn't be wise at all.
I implore us all to gain knowledge on the bail application system in Uganda, because this is one of the very essential facets of criminal justice within our system that accused persons can use so that they can know that they don't have to stay in prison for a long time.